Justice Bernabe.
Okay. Counsel, under the RH law, what is the public interest that the state seeks to protect?
The Congress, during the deliberations, has always referred to as one of the principal interests the aim to reduce maternal deaths. And I think implied in the law itself, considering that about 80% of the law is about contraception, the aim to control population as well.
All right, but now you claim that the RH law violates the freedom of religion, and of course this is on the aspect of the free exercise clause. And the free exercise clause has two parts: the freedom to believe, which is absolute, and the freedom to act on one's belief, which can be regulated by the state. So you are referring now on the freedom not to act, which refers to the act of referral by a conscientious objector of a person seeking care to another facility or to another healthcare provider.
That's correct.
Is that correct?
That's correct.
Now, you also said that the act of referral violates the free exercise clause because you are effectively leading another to commit a serious sin.
That's correct, Your Honor.
Okay. Now, what serious sin are you talking about?
We're talking about the belief among Catholics, and it's in the church teachings, particularly Humanae Vitae, that artificial contraception is intrinsically evil and immoral. And therefore, to be part of contraceptives would violate that Catholic belief.
Okay. But isn't it true that the act of referral merely provides information or access to family planning services to enable a patient to have an informed choice or decision?
Yes, the problem is the conscientious objector participates if we believe that contraceptives are bad. It does not matter if we do it directly, which obviously is a sin, or we lead another person to commit that sin. Material cooperation is something that prevents us from doing that because of our belief that it is intrinsically evil or immoral.
But the patient still have to make a choice. Is that right?
It is not about the patient, Your Honor. The free exercise ground that we raise is from the point of view of the conscientious objector.
Okay. Now, would you agree that physicians usually make referrals if a particular medical skill or ailment of a patient is not within their medical competence or specialty?
That's correct, Your Honor.
And this is, of course, a common practice among physicians.
Yes, Your Honor.
Now, would you agree that the act of referral is a performance of one's duty to provide information or access to family planning services?
Outside of the law, Your Honor, if we discount RH law, there is no such duty with regard to reproductive health services. It is only this law that imposes that. The problem is, if you are a conscientious objector, it will require you to violate your own beliefs. That's what makes it objectionable, Your Honor.
If you're a skilled health practitioner, and this is one of your duty, and your religion prohibits you from doing it, don't you think this skilled health personnel should just resign from his work rather than taking a job that his religion prohibits him from doing something?
That's what's wrong with this law, Your Honor. It makes the conscientious objector choose either of two things. One, obey the law and in the process violate his own faith, or obey his faith and face the consequence of fine or imprisonment. That's precisely what is objectionable, the creation of a burden in the exercise of religion.
And you believe that the act of referral is very intrusive and burdensome, and it does not cause simply a mere slight inconvenience?
No, Your Honor. Our teachings say it is intrinsically immoral, and a person who participates in the commission of that sin commits a grave offense. That's the precise term used in the Catechism of the Catholics.
Okay, can we go to the freedom of speech and expression?
Sure.
What is the rationale behind the guarantee of the freedom of speech and expression? Is it not the rationale is to have a robust marketplace of ideas?
That's correct, Your Honor.
Now, if the conscientious objector prevents the dissemination of information on family planning and reproductive health care services by reason of his ethical or religious conviction, doesn't he contradict the very rationale of the freedom of speech and expression?
No, Your Honor. In fact, in the U.S. case of West Virginia Board of Education versus Barnett, which has been cited by this honorable court several times, it says that the freedom to speak out what is in your mind includes the freedom not to speak that which is not in your mind. In other words, it's part of your freedom to express your thoughts. Not only the freedom to say it, but also more so, the freedom not to say something that is against your conscience.
Now, under Section 5.23 of the implementing rules, the conscientious objector who is mandated to refer may still provide messages of disclaimer, like he can always explain his thoughts after the very act of referral, or he can put posters or advertisements that communicates his position. Is that correct?
I think, yeah, it's in the implementing rules.
Now, by doing this, the conscientious objector really dissociates himself from the position that he does not believe in, right?
Not necessarily, Your Honor. I think these requirements imposed by the IIR create a burden similar to what is created in the law itself, because it imposes certain duties, the performance of which will violate his faith.
Would not this association make it fall beyond the mantle of the protective speech?
If it's the association that's doing it, Your Honor, then there will be no instance of the exercise of religion. But individually, I think it will still be a burden violative of free exercise if that rule will impose a condition on the conscientious objector to do certain things, which by doing, he will violate his faith.
And you call that a practice of religion?
Yes, Your Honor. Free exercise.
Okay. Thank you, Counsel.
Thank you, Your Honor.